Coming to the EU perspective, speaking about the blocking regulation became something of a habit the last few months and even the last year, because not much has changed really, but that has changed again with the opinion of the Advocate General in Bank Melli versus Telekom Deutschland. In the case, the German branch of Bank Melli Iran entered into a framework contract with Telekom Deutschland for the provision of telecom services. Under German law, the contract could be terminated at any time after a statutory notice period without reason. The bank was sanctioned by the United States on 5 November 2018, pursuant to a sanctions regime covered by the EU blocking regulation. 11 days later, Telekom terminated its contract with the German branch's bank. The bank sued, asking the court to order Telekom to continue providing contractually agreed services, so not for damages, but simply to stick to the contract. The German court of first instance held that Telekom's contract termination was valid and did not violate the EU blocking regulation. And the bank appealed, and the appeals court submitted 4 questions to the Court of Justice of the European Union. And this is what the opinion of the Advocate General is about. So let's start with the first item, the scope of the activities. In this respect, the Advocate General observed that the blocking regulation forbids compliance with any requirement in the listed US sanctions. The blocking regulation, the opinion states, applies to any action to comply with any of the listed US sanctions, even, and this is not very surprising, of course, but this was the question, even in the absence of instructions or requests by any administrative or judicial body. Unfortunately, the opinion is limited to the concept of the termination of contracts. It does not address which other compliance would be improper, but of course, it doesn't take too much imagination to realize that if a party would decide not to engage in a contract because of US sanctions, that would also be targeted by the blocking regulation. Before taking a look at the second item, we should have a look at the third one. The consequences of a breach. In this respect, the Advocate General opined that the blocking regulation obliges courts to require performance of contracts terminated in breach of the blocking regulation. So the Advocate General admits that this creates difficulties for EU companies in light of the potential penalties following from US sanctions, but considers that performance is necessary to give effect to the EU public policy. So this is exactly where you do not want to be as a European company, of course. If you think this is bad news, it gets even better. If we look at the second item, which concerns the reasons for contract termination. So in this respect, I think it would be good to have a look first at the wording of Article 5. Now the question submitted by the German court: can this part of Article 5 be interpreted as imposing an obligation for EU persons to give reasons ab initio when they terminate a contractual relationship with a person subject to primary US sanctions? And briefly summarize, the Advocate General opined as follows. Bear with me. While the text of the blocking regulation does not impose such a requirement, the EU person must indeed provide the reasons for termination once there is a dispute with the counterparty in order to give effect to the blocking regulation's aims. The point is that the counterparty would not have the ability to prove that the contract was terminated in violation of the blocking regulation if the EU company does not provide its reasons for doing so. And not only should companies provide the reasons for termination, but they also need to justify these reasons. So they have to explain why that particular decision was made in that particular way. And last but not least, and this is a matter of national law for all EU member states.